The Journal of Obstetric, Gynecological, and Neonatal Nursing published an article stating that birth certificate data with low accuracy is not better than nothing. Rather, the use of such data may lead to incorrect conclusions. Varied reliability and validity of birth certificate data undermines insight and rational public health strategies. Tracking and diagnosing disparities in mortality based on age and sex. Identifying differences in life expectancy based on age and sex. Evaluating socioeconomic inequalities by sex and age. Identifying disease epidemics such as the Zika virus that disproportionately affect one sex. Exposing bioterrorist attacks. Identifying criminals, and preventing identity theft and fraud.
This legislation would require that the facts contained in the birth certificate, the information contained therein, the most important of the vital records kept by the state, would reflect the objective facts as they existed at the time of birth. To do its jobs well, the state needs government documents to contain accurate information. Among the most important functions of state governments include law enforcement, criminal justice, and public health. When the state cannot effectively carry out these responsibilities because the vital records they are relying upon are inconsistent and don't reflect objective facts, families are made less safe.
The amendment of material facts requires material proof. Primary controller of biological sex is our genotype. Archaeologist or a medical person could look at the chromosomes in any single cell of our body and distinguish that this was a male person or a female person, and archaeologists do it all the time, even hundreds of years sometimes after someone has passed away. In addition to that, new science is showing us that our genes express differently in biological males as opposed to biological females in every cell of our body. So as many as a third of the genes that are not specifically XX or XY genes express themselves differently in males as opposed to females. There are sex-specific policies that impact us all. Sex-specific protections like Title IX. Sex-specific athletic associations. Sex-specific locker rooms and restrooms. School policies like overnight accommodations on a field trip. Sex-specific university dorms or housing. Car insurance policies and rates. Medical insurance policies and rates. First responders and emergent care personnel who rely on sex-specific identification to implement the appropriate sex-specific treatments. Did you know that if you have to receive a blood transfusion and you're unconscious, you'll likely get different blood depending on whether you're a male or whether you're a female? Because type O negative blood is very rare, and they reserve that for females who may happen to be Rh negative and may develop a condition that would prevent them from ever having children thereafter if they receive the wrong blood transfusion. Sex-specific policies in religious organizations that are intimately tied to people's faith and religious beliefs. Those who provide youth camps, juvenile corrections facilities, prisons and jails, mental health hospitals, and medical health care providers. In all of these circumstances, situations, institutions, we have established sex-specific policies in order to protect the health and the safety of the public at large. These policies were not discriminatory, and they were not random. They were established in part because women historically have been the victims of significant sexual abuse and crime primarily at the hands of males. And I won't go into the statistics on that right now, but I'm happy to. If you look at statistics on sexual assault and rape, you'll find that overwhelmingly women are the victims and men are the aggressors. And I believe this is in part simply based on the biological differences between men and women that affect the aggressive nature of the sexes and the ability of different sexes in terms of self-defense. All of these policies respect those biology-based differences and provide for the protection of the health and safety of the public at large.
There are real dangerous people in our communities. There are predators. These people will use the ability to change the sex that good intended people would like to see to unintended and harmful ends. One of the most concerning aspects of this for me is what happens in jails, which are segregated by sex. These people are in prison for a reason, and we have segregated prisons and jails for a reason. People who are in these facilities have been convicted of breaking the law. They cannot be trusted to have good intentions. How will we protect women?
In public accommodations, a biological male could use his female sex designation on the birth certificate to defend his desire to use female locker rooms and showers. A biological male could use his amended birth certificate to gain access to a shelter designed for women and children who are victims of domestic violence. A biological male prisoner could rely on his amended birth certificate to assert that he should be housed in a women's prison. These examples aren't far-fetched. All three have already taken place in other states. In each of these cases, vulnerable populations, women and children, are made decidedly less safe because of the policy allowing the birth certificate content to be changed.
If we change the legal definition of sex from a biology-based definition, which is what this research and these policies reflect, then we fundamentally alter existing public and private policies and contracts that rely on that definition. And I'm going to quote from Ruth Bader Ginsburg. She said, in regard to the Equal Rights Amendment, which was a predecessor to Title IX, separate places to disrobe, sleep, perform personal bodily functions are permitted, in some situations required by regard for individual privacy. Individual privacy, a right of constitutional dimension, is appropriately harmonized with the equality principle. Treating some biological males, and by current policy, I mean the policy that allows you to change the sex identifier on your birth certificate with just a signature. This treats some biological males differently from other biological males simply because they have a government-issued piece of paper, and vice versa. Some biological females may be treated differently from other biological females based on the issuance of a piece of paper. But the Equal Protection Clause does not require that things that are different in fact be treated as the same under the law. The driver's license is more of a social document than the birth certificate because it reflects a person's current status and description, while a birth certificate is a description of that individual at time of birth. Sex is a vital statistic. Gender and identity are not. Society has many legitimate interests in recording and maintaining accurate information about its residents' sex for purposes of identification, tracking crimes, determining eligibility for sex-specific programs or benefits, and determining admission to sex-specific spaces, to name just a few examples. In contrast, there is no legitimate governmental interest in recording a person's subjective identity or giving that identity legal significance in lieu of biologicals. What we are talking about today is not just whether some individuals have a right to alter the sex identifier on their certificates to make it congruent with their preferred identity. What we are talking about today is whether the legislature of the state of Idaho, acting as representatives of the people, have a constitutional right to choose the legal definitions that will undergird our state policy. The birth certificate does not say gender, it says sex. And what I am arguing is that sex should be, as it has been historically, a legal and scientific term related to biology. There is a logical fallacy that is called begging the question. When someone begs the question in an argument, they assume the conclusion to be true and then use that conclusion as the basis to prove that it's true. So let me give you some examples of this, where sex is assumed to be the equivalent of gender identity and not to be biology related. In the Westlaw Minutes of FV versus Barron, on page 3, they comment that a transgender individual who has undergone clinically appropriate treatment to permanently change his or her sex. Think about that for just a minute. If sex is real, if it never changes, and it never goes away, biologically, we are replacing the biological definition of sex in this statement with another definition. The mismatch between gender identity and the sex listed. Again, we're assuming that the sex listed should be defined by gender identity. That's on page 6. On page 7, the plaintiffs argue that the Idaho Department of Health and Welfare's refusal to treat transgender people like others of the same sex assumes that the term sex is defined based on gender identity and not based on biology. From page 8, these laws give certain people access to birth certificates that accurately reflect who they are while denying transgender people as a class access to birth certificates that accurately reflect their gender identity. Again, the court has assumed that gender identity and sex are equivalent in their definitions, which means sex is not defined biologically. Transition, as we're talking about gender identity, is often limited to social transition. Sex is not just a social term. It's a legal term. It's a scientific term. It's real. It doesn't go away. It matters to us for a variety of reasons. And it fundamentally impacts our ability as a state to fulfill our responsibilities in government and also to protect the health and safety of our citizens. You cannot protect what you cannot define.
Just curious, during the court hearings, was the birth certificate, was the marking on the birth certificate referred to a gender marker or as sex? Because our birth certificates say sex, not gender marker.
We speak to it as a gender marker, but the issue of whether you're talking about sex or gender marker, that was discussed and addressed at the court. Gender marker being the notation on the birth certificate called sex.
There's a variety of ways that we pay for public policy. Sometimes we pay in money, and sometimes we pay because we made a choice that has negative repercussions.
Accurate birth certificates are a precursor to obtaining many other forms of identification and are necessary to access a myriad of health and social services, from direct health care services to insurance coverage to public benefits. making it particularly important that individuals possess accurate birth certificates that match their gender identity. All people deserve access to high-quality, gender-affirming care and social services that meet their needs. Many members of the LGBTQ community already face significant obstacles to obtaining and benefiting from physical and mental health care services, including low rates of health insurance coverage and high rates of discrimination from medical providers. For example, the 2015 U.S. Transgender Survey found that nearly 1/3 of transgender people who showed identification that did not match their gender presentation were verbally harassed, denied benefits or services, asked to leave, or assaulted. And LGBTQ youth are disproportionately likely to be in the child welfare system and be experiencing homelessness, creating additional barriers to care. These barriers contribute to health disparities among LGBTQ populations, including increased risk of suicide and depression.
I believe that everyone has the right to live authentically without prejudice or harassment. People who do not have the means, access, or desire to medically transition will face unnecessary and unjust violence and discrimination for the rest of their lives.
Transgender people have been harmed when their documentation does not match their outward appearance. This harm ranges from inconvenience when boarding an airplane to flat-out assault and even murder.
The court made clear that any barrier erected by the state, by rule or by statute, for transgender people to obtain birth certificates matching who they are will be presumptively invalid. If this law passes, it will place state employees in the position of either following the statute or following a court order, because they cannot do both.
Today, we are here to oppose House Bill 509. We strongly support the ability of transgender Idahoans to reflect their gender identity on their birth certificates. We believe the proposed medically invasive testing places an unnecessary burden on the community. While birth certificates were originally used simply for historical purposes, they have now evolved into necessary documents for daily life, including education and operating a motor vehicle. According to the U.S. Department of Health and Human Services, birth certificates are also used extensively for employment purposes to obtain benefits or other documents, for example, driver's licenses, social security cards, and passports, to assist in determining eligibility for public assistance and other benefits, to enroll children in school, and as proof of age eligibility for sports and other age-restricted activities. The proposed changes would make it extremely difficult for transgender Idahoans to go about everyday life for several reasons. Requiring signed forms from a licensed professional creates an undue burden for those attempting to enter the workforce. These changes make it more difficult to obtain employment when documents do not match their gender identity. To require someone to have signed forms from a licensed professional could possibly delay employment, support discrimination, or eliminate an opportunity at gaining employment completely. According to one legal researcher, some employers may discriminate against a transgender person, especially in the hiring process, when the employer inspects identity documents that do not match a person's gender presentation. In much of the United States, this discrimination may be viewed as legal. In addition to unnecessarily revealing a transgender person's identity, this process could make it harder for someone to change their gender on their birth certificate, creating delays in employment. Additionally, the proposed changes would create a problem for people needing a driver's license that properly reflects their gender identity.
Transgender women are women, transgender men are men. Just like those on this committee know in their hearts and souls that they are women or they are men, transgender people know exactly who they are, and that is the way they present in the world, or at least that's the way they should be able to present in the world, safely. Arguing biology to deliberately misgender people in this committee room is both cruel and a misinterpretation of actual biology.
My name is Emily Jackson Edney, and my pronouns are she, her, and hers. I don't identify as a woman. I am a woman. As a result of the U.S. District Court ruling in March 2018, the state of Idaho and their various administrative agencies now recognize this as fact. All my identity documents are now congruent with my name and gender marker. These include my Idaho birth certificate, Idaho Star driver's license, Social Security Administration, U.S. passport, and copious other identity documents. All of these allow me to navigate smoothly through our society and in everyday life with relative safety, free from demeaning harassment, humiliation, heightened scrutiny. It is not the purview of the state of Idaho to determine what it means to be a man or a woman as it relates to me personally. I'm the only one that can do that. Thank you very much. I did not transition gender to be a real woman. That in itself is a useless concept and a fairly sexist and transphobic one. I transitioned to be a woman, my kind of woman, the kind of woman I want to be. And that involves expressing myself as I am, a whole person, in ways that break gender stereotypes as much as caters to them. A woman is so much more than chromosomes, genitalia, reproductive organs, or some sort of statistic in a government database. It never ceases to amaze me that those cisgender detractors who disparage transgender men and women actually have no skin in the game and seem to arrogantly feel they know more about the lives and the needs of transgender men and women than do the transgender men and transgender women themselves.
There have been no harms from transgender people having access to corrected birth certificates in Idaho, just as there have not been any harms in the 48 states where such policies exist. And just as there haven't been any harms from allowing transgender people to correct their gender markers on their driver's licenses in this state. Changing the rule that is currently in place as a result of that court order is a solution in search of a problem. It makes no sense to turn back the clock and again make Idaho an outlier in this country. Finally, the only change in the last 2 years is that transgender people face a lower risk of discrimination, harassment, and violence because they can access identity documents matching who they are. Everyone needs accurate identity documents to navigate everyday life. This was a major part of the briefing that included to the court. Study after study has shown that when transgender people are forced to use identity documents that disclose that they are transgender, they put their safety in jeopardy. These are documented harms, which were proven and discussed in the litigation. The court found that nearly 25% of college students and workers in the workplace who were perceived as transgender were verbally, physically, or sexually assaulted. It found that almost 50% of transgender people reported being verbally harassed.
No known issues since the rule was implemented in April of 2018. Many of our Western neighbors that permit transgender people to complete that change via self-attestation, which removes unnecessary and discriminatory burdens that transgender folks may face at the hands of government.
When a person who is transgendered takes the responsibility of doing the work, going through the medical procedures, and becoming the person that they know they are to be, that they know they are. Idaho, as a general rule, respects that, and that's why the procedure of changing the birth certificate has really become very logical and simple.
Transgender people are simply trying to live authentically as their true selves and attempting to safely navigate through and participate fully in our society, which HB 509 attempts to impinge. U.S. District Court Candy Dale, in her March 2018 ruling against the state of Idaho, held that denying a transgender person the opportunity to change their gender marker on their Idaho birth certificate to match their lived gender identity violates the Equal Protection Clause of the 14th Amendment of the Constitution of the United States, in that it infringes on the rights to informational privacy, individual liberty, autonomy, and dignity. The U.S. District Court didn't instruct Health and Welfare about the manner in which the birth certificate gender changes were to proceed, But Judge Dale did caution the state from creating a new rule that would subject one class of people to any more onerous burdens than the burdens placed on others without constitutionally appropriate justification, including the need to provide evidence to include things like complete DNA, chromosomal workups, and medical attestations. Now, I don't claim to be a legal scholar by any means, Mr. Chair, but to this lay person, House Bill 509, birth certificates, before you today violates the judge's instruction and therefore could be subject to additional judicial scrutiny, which can be an expensive burden to the Idaho taxpayers.